Welcome to Money Chat Today with your hosts Larry Steinhouse and Rick Lee. From the School of Hard Knocks, they present with years of knowledge on how to help you make more money and how to keep it.
Hi, I'm Larry Steinhouse.
And I'm Rick Lee.
Welcome to Money Chat Today. This is a show where we help people make more money and help them keep it. And today we have a special guest. Our special guest today is Scott Fegley. And Scott Fegley is an attorney. And Scott has been representing clients in a wide variety of civil matters for over 24 years. In 1984, he graduated cum laude from Lafayette College. He received his Juris Doctor from Villanova in 1987, and he is a member of the Phi Beta Kappa National Academic Honor Society. After working for firms in Philadelphia and Princeton, he started his own practice, and now he specializes in employment and environmental law. Scott is also very active in the community. He was elected to 2 terms on the Lower Makefield Township Board of Supervisors. He has served as legal counsel on many organizations, including Livengren Foundation. Welcome, Scott.
Welcome, Larry. Yeah, glad to have you. Welcome.
Hey, Scott. Actually, I'm really glad that you came today because, a lot of our viewers are they're small businesses. Maybe it's just them. Maybe it's them and an assistant. Maybe it's them and maybe 1 or 2 employees. And I know there's a lot of laws out there about employees versus contractors, and I know that's what you specialize in, and that's what we really want to talk today about. Really, I see this happen all the time. A while back, I was in the real estate business, and people would hire assistants, and I know there's kind of laws, and they're kind of vague to the average person, and I'm kind of hoping you can straighten them out. If I was to hire an assistant, even in this business, let's say even in our video, if I was to hire an assistant to actually do the camera work or do something, what should I be aware of?
Well, first I want to go back, Larry, just to straighten the record. I don't practice environmental law. I practice business, employment, and personal injury law, so I wouldn't want your viewers to get the wrong impression on that. I have no experience in environmental law whatsoever.
Oh, sorry about that.
In the employment arena, I certainly can help you there. I think one of the big issues today is the distinction between employees and independent contractors. A lot of businesses typically make this mistake. They are trying to save some money, and they will often, sometimes unintentionally, sometimes intentionally, classify their workers as an independent contractor so that they don't have to pay the taxes, so they don't have to pay the matching employer's contribution, and thereby save a little bit of money, save a little bit of administrative headache. Unfortunately, this can cause a much bigger headache down the road if an employee challenges that determination.
So basically, paying somebody under the books is probably a bad idea.
Well, it's not only paying them under the table, it's misclassifying them as the type of employee or independent contractor that they are. An independent contractor is somebody who theoretically works for themselves. They set their own hours, they have their own supplies and tools, they have their own way of doing whatever the work is that is asked to be done. They're not being instructed by the person hiring them as to what they do. An employee, on the other hand, as we all know, you go to work, your employer tells you what to do, you have an assigned task, you work a set number of hours, and that's more of a typical employment relationship. There's a lot of gray area, there's a lot of different situations where we go from the one extreme where we understand the employee goes to work every day for the same employer, and the other where the plumber comes into your house and he's an independent contractor. But there's a lot in the middle there where people are not clear about.
So and I guess it goes back to I guess it goes back to the basics. Again, if I'm hiring an assistant in the example I gave earlier, and they have a specific job, they know that they need to do something. I don't know. I'm trying to use a great example. Let's say a secretary for for a lawyer or for an accountant. If that person needs to come to hours a certain time and do a certain job, that makes them the definition of an employee?
That's the typical employment relationship where the person comes to your place of business, you give them the supplies and tools, you tell them what to do, and they do it for a standard period of time, whether it's the full 9-to-5 work week. It doesn't have to be, it can be any set schedule of hours, and they're doing what you tell them to do as you instruct them to do that. Whereas an independent contractor, you say, well, here's the job that I like to have done. Again, Think of a plumber that you might ask to come to your home to fix a leaky faucet. You don't tell the plumber when to show up, he tells you when he's going to come. When he arrives at your house, he brings his own tools. He does the job. You don't stand there and say, well, you know, that's how I'd like you to do it. He does it his own way. That's the typical independent contractor. Now, another household example we might use is a maid or a housekeeper. In some cases, they may come in for a set schedule of hours. They use the homeowner's supplies. They do exactly what the homeowner asks them to do, and even in the way that the homeowner tells them how to do it. And in some cases like this, homeowners have gotten themselves into trouble by paying these people as independent contractors instead of part-time employees.
Wow, you mean an actual house cleaner?
That's correct.
So if my neighbor said, hey, you know, I'm going to start doing house cleaning, and I just said, yeah, why don't you come over for the next couple hours, clean the house, and pay her? That can actually be classified as an employee?
That's potentially an employment situation.
Wow.
That's why you have to be careful. So if you're hiring a house cleaner, you want to know, do they have their own business? Are they working for other clients as well? Have they set up their own company? Whether it's a limited liability company, do they have insurance? Those kinds of things. These are questions that you definitely want to ask before you just have someone come in and start cleaning.
Wow. Well, assuming they don't have insurance, I mean, and you know, I kind of always try to look at the way around. So, I mean, if they just had a business card, would that be enough to prove that they were an actual business?
No, business card doesn't mean anything.
Really? Wow. Wow. So you want to make sure that they have other clients.
Mm-hmm.
You want to make sure that they may have some kind of entity. I mean, look, it's obvious that there's some insurance problems. I mean, they may steal from you. They may, hopefully not, but they may break something. They may get injured in your house. These are all other issues that are really important.
These are definitely some of the concerns with regard to a potential injury, because an employee has the right to workers' compensation. If you're not insuring them for workers' compensation, then you can be subject to fines and penalties for not having the proper workers' compensation. With regard to unemployment, an employee who is terminated or loses their employment is entitled to unemployment. A lot of these situations come to a head when the person, after losing their job, goes to unemployment and says, you know, I'd like to get unemployment benefits. And the unemployment agency says, well, no, we see you were an independent contractor here. Right. The employee says, no, I really wasn't. I work just like an employee, and then that'll start an investigation where the unemployment agency will now be looking into whether or not this was in fact an independent contractor or an employee relationship. And if you're wrong, then you're going to owe back unemployment taxes and again some potential fines and penalties.
Wow.
Right, plus as a homeowner, I mean, the worst case scenario is you have somebody come into your house to work and they get injured. Not only could you have all these penalties for failing to carry work comp, but you could be sued.
Yes, if you don't have the workers' compensation, then they could sue you directly for any injury that they might have.
Well, it's amazing. Look, so what if I have my house cleaner come in and, you know, before she even starts, I have her put down a piece of paper and sign that she's an independent contractor, or even, you know, maybe the house cleaner, maybe not even a good example, maybe my secretary, my assistant that I bring in, say, you sign this that says you're an independent contractor, and do I not have to worry anymore?
No, signing a contract doesn't really mean anything. It's one factor that a court might look at, but what the courts look at, when the unemployment agencies look at, when they're considering an independent contractor versus the employee relationship, is the control that's actually exercised over the employee. So once again, if you are telling the person what to do, how to do the job, you're telling them when to do the job, and you're providing them with the tools to do the job, you're employing them.
Well, let's even take another example. What if I own a repair shop? And, you know, I have guys who come in every day and they work on the cars. They report to work at 8 o'clock in the morning because cars start coming in at 8 o'clock in the morning, but I pay them by the job. And they own their own tools, most of those guys do anyway, and they own their own tools. Can that be classified as an independent contractor, or am I walking the fine line here?
Well, again, you're walking a fine line. I think if the courts look at all of the factors of the relationship, not just one, there's not one particular factor, or there's no checklist where you can go down and you can check it off and say, okay, if this person is doing that, then they're an independent contractor. They look at the control. So in your auto repair shop example, what I would want to know is, are these people who are coming in and fixing the cars, are they working for anybody else? Are they making around the shops, or are they only working at that one shop? If they're only working for that one shop, if they're coming in at a specific time and leaving at a specific time, even if they're getting paid by the job, then that is more of an employment type relationship. Because again, they're doing what the employer is asking them to do. Just because that they, in that particular case, own their own tools, that doesn't mean that they're not an employee.
So it sounds like a big key is if they have other people they're working for.
The big key is the control.
Okay.
The big key is,
Right.
do I, as the employee or independent contractor, have the flexibility and freedom to do the work in the way that I choose to versus the way the person who's paying me is telling me to do so.
Oh, interesting. Okay.
Right now, in Pennsylvania, last year, Pennsylvania passed the Construction Workplace Misclassification Act, and this is clamping down on contractors who do make this misclassification between independent contractor and employee. Now, in Pennsylvania, it only applies in the construction industry, not to other trades and businesses. But again, this is a growing issue. The federal government has, right now in Congress, there's a proposed act called the Fair Playing Field Act, which again is trying to clamp down on employers who either unintentionally or even intentionally try to misclassify employees as independent contractors. And under these new acts, what they're establishing are tests. They're requiring not only the written contracts that you spoke about, but they're also requiring that to be an independent contractor, the person has to be completely free of any direction or control or training by the person hiring. And then furthermore, that there also be evidence that this person is actually in his own established business, that they have maybe a corporation or an LLC set up. LLC is a limited liability company, or they have invoices and documents which companies typically use to do business, so that they can establish that they have their own business and they're not just a neighbor or friend that's coming in and is being paid as an independent contractor when they should be an employee.
Well, it's kind of obvious the employer who's trying to use the independent contractor, I don't know, excuse. They're subject to fines. But what about the employee? Can anything happen to him because he went into this kind of arrangement?
No, not from the fines and penalty standpoint. What the employee loses by submitting to this type of arrangement, by being an independent contractor when in fact they're an employee, is they end up paying more taxes than they should be. Really? Because they are being paid as a self-employed person. They have to then pay and report more taxes as a self-employed person. And the employer is not making that matching contribution for them that gets credited towards their Social Security. So they end up paying more in taxes, but there's no penalty against the employee, even if they would sign their name to a contract saying I'm an independent contractor, because the government places the burden on the employer. The employer should know better. The employer should know who is an employee and who is an independent contractor. So
here you go. Obviously, there are quite a few reasons not to do this incorrectly.
That's correct.
And really, you have one person. I know I'm trying to border on giving somebody advice, but what can really happen to somebody? I realize penalties, fines, but when you look at it, and I hate to say it, but sometimes the penalties and fines are less than the costs of doing this correctly.
Not in this case.
Okay, good.
Not in this case. This is one situation where the amount of money that the employer can save by misclassifying employees, by not paying the matching contribution, by saving some money on the administrative work, pales in comparison to the potential fines, penalties, and back taxes that they could pay. Also, just as another example, if this is an employer who employs lots of employees and is doing this with lots of employees, they could be subjecting themselves to a potential class action lawsuit, which means that all the employees get together and bring the lawsuit as a class rather than just one individual person. You may have heard some examples in the news about large corporations who typically the class actions deal with overtime pay and things of that nature,
Right,
but
sure.
this is something that could be subject to a class action lawsuit as well. And not only are the potential, again, back taxes and penalties and everything are going to add up to potentially hundreds of thousands of dollars, but then think about all the legal fees and costs that you're throwing in as well.
Remember, I think it was Merck had a big case where they had a computer consultant as a contractor, and they were paying them as a contractor. And the guy was there for somewhat 10 or plus years, and he left, and then he sued them for the retirement package, which for the pension, which was amazing, which actually shook up. I was actually in the computer consulting business years ago, and that shook up the whole business and put down all kinds of rules where the employers wouldn't keep anybody more than 18 months to 24 months now. Because they were afraid of this. Because the guy was there for 10 plus years, and he felt, and the attorney argued it and won, and felt that it was that he was really an employee. I thought that was amazing.
Wow, that's a classic example of what can happen with a misclassification situation.
Wow. So now you also represent individuals on some other issues as well, and and one of the things that comes to mind, especially when we're talking about employment law and these times, is the fact that a lot of companies are cutting back. They're laying people off, or they realize that, hey, they got a $100,000 a year employee here who's maybe 58, 60 years old, and they could probably replace him with a 23-year-old kid out of college for half the money, and they come up with a reason to let this guy go and bring somebody in. Are you seeing cases like this, or are you hearing about cases like this?
I've definitely seen age discrimination cases in my office. Now, I don't have any data to suggest that there are more age discrimination cases occurring now in this economy versus, say, a few years earlier. But certainly, this type of economy that we're in provides employers with, unfortunately, a much better cover, if you will,
sure.
for laying people off with an underlying discriminatory motive. Because the challenge for any attorney representing individual employees is to be able to demonstrate that the discriminatory factor was part of the employment decision, the decision to terminate the employee, and not just an economy. People can be laid off for any reason, and especially in this economy when obviously lots of companies are having financial problems. It's a perfectly valid and legitimate reason for laying people off. We have to look for other evidence, whether it be some kind of statements. I had one case where prior to this person being let go, the supervisor had come into the office a couple of times and said, "Hey, why aren't you thinking about retirement?" So something like that would be a tip-off that maybe there's something more here than just the company's economic problems.
Yeah, exactly.
Sure.
So something like that is what we look for. But when somebody comes into my office and simply says, "Well, 15 people were just laid off in my company, and I just happen to be the oldest one," but they also laid off people in their 30s and in their 40s. It's a really tough situation to then say, well, you were subject to any age discrimination just because you happen to be the oldest one who was laid off.
Sure.
It always depends on the facts of each individual case.
Right. Well, let me ask one question that's often come up. At a recent job, it was explained to me that the concept of at-will employment, in other words, does the employer need a reason to, it was my understanding, and I would like your clarification on this, that at-will employment means that either the employee or the employer can sever the relationship at any time for any reason.
Or no reason at all.
Right, or no reason at all. Now, is that totally legal?
That's exactly what it means, and that is legal, and that is the doctrine here in Pennsylvania and in most states in the country. At-will employment, and it does come to a shock to a lot of employees who have never heard of that phrase, but at-will employment means just what you said, that it can be ended at any time. The employee can just get up and walk out and leave the job without any notice or anything like that, and the employer can simply say, "We don't want you working for us anymore." The employee could have been an excellent model employee, and the employer might have a relative just graduated from college and wants to fill that spot. Well, unfortunately, fairness and morality are not the standard for the workplace. It's again what the employer wants.
Right. So if there is this at will in Pennsylvania, how do you bring a let's say like a wrongful discharge
That's a really good
lawsuit
question.
if an employee feels that they were quote unquote unfairly let go? Does there have to be some element of discrimination, whether age or race or gender? Or
Well,
how do you bring lawsuits against employers?
in employment law, we start with the general background of at-will employment, and that an
Right.
employer can fire anybody for any reason or even no reason at all. But then from that background, the state legislature, Congress has carved out certain areas, such as discrimination, where they say that you cannot fire an employee for particular reasons. Namely, you cannot fire them because of an age, sex, race, all of the what we call protected class features that the anti-discrimination laws protect against.
Right.
They also, there's what they call common law, where for wrongful discharge, there's no specific statute, but nevertheless, you can't be discharged, for example, for refusing to do something that's illegal. If an employer asked an employee to commit a crime and the employee said no, and then the employer fires them for that reason, then that would have an action for wrongful discharge in that case, although there's no specific statute that says to an employer, don't fire somebody because you're asking them to commit a crime. So there is a general common law area for wrongful discharge, but a lot of the litigation that takes place is with regard to the anti-discrimination laws that have been passed.
Right.
But it's kind of odd to me that let's say somebody hits their 70s, whatever, and you walk up and we've decided to terminate your employment, and if that's all you say, and that's it, and the real underlying reason, but there's no one actually said it, no one proved it, no one did anything that could have led to this guy being let go for age discrimination, even though that really is the underlying cause in the back office somewhere. How can he actually come back and say, well, it wasn't age discrimination?
Well, again, any case, whether it's employment law or any other area of the law, depends on the proof and the evidence that you have. And that's our job as a lawyer to find out what the surrounding circumstances are. Was this individual who was 70 the only person laid off, or was he among a number of people who were laid off at the same time? If he was the only person that was laid off, and the company was doing very well despite the economy, and the person that they hired to replace him was in their 20s, then I would be very suspicious, and I might think that this would be a potentially good case to bring as an age discrimination lawsuit. On the other hand, if this person again was laid off amongst 20 or 30 individuals in the company, and there were several younger people that were laid off at the same time, and the company was struggling, then I don't have the evidence to make a good claim that just because this person was in his 70s and was laid off, that age was a motive.
I guess I'm struggling with the employment at will portion. If you're an employee at will and all you do is let somebody go and say you're no longer employed here.
That's correct.
It's kind of hard. I mean, I'm looking at you. It might be hard for you as an attorney or any other attorney to come up with any other reason that it was just an employee at will decision.
Well, again, once you have to look at the facts of every case. You have to ask the client when they come into your office all the questions that you're digging for to explore the situation. Is this individual being singled out, or is there a particular group of individuals? Did the company, when they conducted this layoff, lay off everybody who was over the age of 50, or again, are there younger people involved as well? When you look at a layoff situation, employers are required to follow certain rules in layoff situations, and they're often called reductions in force. And they are required to, in order to get releases from the employees, to provide them with a list of who's been laid off and their ages so that they can see.
Wow.
These, again, are all questions that we ask in the initial interview, and we try to get to the bottom of what's going on through our questions to understand, again, is this person being singled out? Is there some individual factor that's why they're looking at this particular person, or is the company really just struggling economically and doing the best they can and making some tough decisions.
So both the employer and the employees should really, really should speak to an attorney before they do anything.
Well, I think it's always a great idea because you're talking one consultation.
Right, exactly.
To go in, to lay your situation out on the table,
Sure.
to ask questions, to allow the attorney to ask questions before you sign any piece of paper for a severance package, for any type of legal document, a release, even an initial employment agreement. It's good to know what your rights are.
That's a good point.
Before you commit yourself to something. Once you sign the contract, you sign the contract.
I never thought about that. Often, in past jobs or past careers that I've had to sign an agreement. And I never thought about having the agreement, the pre-agreement signed. Reviewed by an attorney before. That's actually very good advice. So yeah, and it just clicked and dawned on me the trouble that I could have had because of those agreements, and actually sort of had in the past too.
Mm-hmm.
That's a very good piece of advice. I mean, initial consultation, a couple $100. Why wouldn't you want to do that when you're talking about a career that could
not only a career but potentially thousands of dollars in unemployment benefits, in severance benefits.
Sure.
A lot of what I do and what I see in my office are people coming in, unfortunately having been laid off, and asking me about the agreements, and they've been presented with these agreements and wanting to know what their rights are. If you simply sign again, you're releasing all of your rights, and after that, whatever pay you've accepted, and you can't
Sure.
go back and change your mind.
Right, we did an episode a couple of weeks ago about finding a job. I could just imagine someone's laid off. Now they have all this stuff in front of them. Yeah, and maybe it's a contingency case, or maybe they have to lay out some more money to sue someone. But at the same time, the last thing they need is the pressure of having all this, of a lawsuit going on while they're looking for a job. It would be very difficult. So yeah, wow, that was a light bulb moment for me.
Yeah.
Absolutely. Next time I go into any employment contract, or viewers should, anytime they go into any employment contract, absolutely have it reviewed by an attorney beforehand. Very good idea. Thank you, sir. I really appreciate that one.
What are the majority of cases that you see today? Or do you see any patterns?
No, I can't say that I see any particular patterns. I have, again, a mixture of clients with some different types of discrimination case. Unfortunately, you still see sexual harassment in the office, in the workplace. We have a couple of those situations. Unfortunately, employers, I do see, I think, employers contesting unemployment benefits more often now than in the past. With regard to unemployment benefits, basically the only way an employee can be denied their unemployment benefits is if they voluntarily quit, or if they violated a known rule or committed willful misconduct. So I see more employers attempting to argue that either the employee quit for some reason, or that there was a willful misconduct. Unfortunately, employers are, I have had a couple of cases where the employers have given the employee the option of resigning or being fired.
Oh, you're kidding.
And they ask for a resignation letter. The employee in that situation thinks, wow, cool, it'd be a lot better if I simply give a resignation letter, then I can tell my next potential employer I don't have to say I was fired. And they sign that resignation letter, and then the employer sends it into the unemployment office, and the unemployment office says you quit. Well, I've defended a couple of those cases successfully, because that's not a choice.
Sure,
that's not a choice. That's not a voluntary quit situation.
Is that actually illegal for an employer to do that? To say, look, you can resign, or we're going to fire you. Is that illegal?
Well, again, it's not illegal from the standpoint that there's a law out there which it violates. It does not prevent an employee from collecting unemployment benefits. With the at-will situation, the employer doesn't have to give any reason at all for terminating somebody.
Right.
Okay, the question is then, once the employer has acted and terminated this person, is the person entitled to unemployment benefits?
Right.
Is the person, or is the employer, should the employer be charged for those unemployment benefits?
Right.
And a lot of employers try to get by this by saying, oh, they resigned.
Yeah,
But this was not a voluntary situation in these cases. The employee was faced with signing a resignation letter with a gun to their head, basically,
Right, exactly.
and they were entitled to their benefits.
Right. Now, if an employer has already paid into unemployment, which they do, both the employer and the employee pay into unemployment, why would an employer bother to fight unemployment if they've already paid into it?
You pay a specific tax rate, and the more cases of unemployment you have, the more people you have claiming benefits, the higher rate you're going to.
Oh, okay.
So they have a factor. I can't explain how the mathematical calculation works, but the unemployment agency has a calculation, a factor for your tax rate. If your employees are happy and you don't have a lot of people leaving your workplace and claiming unemployment benefits from you, then you're going to have a lower tax rate, pay lower taxes.
Oh, I see.
If you have a lot of people leaving, a lot of turnover, and these people are claiming unemployment benefits, then you're going to pay a higher tax rate.
I see. Okay. Well, that's interesting. Is there anything else that our viewers should know, be aware of? Is there something that we've missed?
Not that I can think of, Larry. I think, again, it's always a good idea for any employee or employer in an unemployment situation, if they have any questions, to just get a consultation with an attorney, because there's so many variables in employment situations. There's no checklist, as I said earlier. There's so many variables that it just pays to have some good advice before you're making decisions that can cost you a lot of money, either from your business standpoint or from your career standpoint. So sit down, talk to an attorney. In many cases, the consultation might be free anyway, and get some advice before you sign a contract or you take some action with regard to your career.
And if people are in our area, Bucks County area, Bucks County, Pennsylvania area, how would they get a hold of you? What is your website?
www.fegleylaw.com.
Excellent. And okay, great. And also there'll be a link below that you can actually link right to Scott's website as well. And thank you all for watching. We appreciate it.